We're joined now by two leading Catholic voices on gender issues, Mary FioRito of the Ethics and Public Policy Center and Ashely McGuire, Senior Fellow at the Catholic Association. Thanks so much for being here, ladies. Mary, talk to us about the legal side of this. What has happened to the words "on account of sex" that's so problematic?
Well, we all knew what "on account of sex" meant in 1972 when Congress ratified the Equal Rights Amendment. That word has a very, very different meaning now, not only in the law, but also in public discourse. And in the Bostock case, the Supreme Court's case, which was an actual employment discrimination case a couple of years ago, what the court held was that Title VII, which is the Civil Rights Act of 1964, Title VII as it's more commonly known, the word sex now encompasses things like gender identity and sexual orientation. So it's a far vaster category than just male and female. And, you know, we know this just from, again, the general discourse about how many genders there are. And with some people claiming that, you know, there's more than 100 different genders. So gender identity, sexual orientation are now considered part of that definition of sex. So the Equal Rights Amendment, just from the get-go, right out of the gate, has a very different meaning legally.
That's right. And we're talking about discrimination and employment discrimination in particular, which is a big piece of the ERA. But let's put that legal issue aside. Give us a little background on why this issue is null and void, according to you.
Right. Well, the Equal Rights Amendment was introduced in 1923 by a pro-life suffragette named Alice Paul. She was the author of the first Equal Rights Amendment. She was so pro-life, in fact, she's quoted as saying, "Abortion is the ultimate exploitation of women." And the ERA has taken various forms over the years as it's moved through Congress. It was ratified by 2/3 of the Congress in 1972, and that moved the issue to the states. And of course, what the Constitution tells us is that to have an amendment to the U.S. Constitution, you need the votes of 3/4 of the states, which would be 38 states in our country. And there was a deadline imposed on that ratification process from 1972 to 1979. When it became clear that ratification wouldn't happen by 1975, the deadline was dubiously extended to 1982. But even then, the ERA was not ratified by 38 of the necessary states. So the vast majority of legal scholars, including Justice Ruth Bader Ginsburg, who said 2 years ago at a talk she gave at Georgetown, if we're going to get the ERA to be an amendment to the United States Constitution, we're going to have to start all over again. So the vast majority of people who look at it honestly and with the intent that the legislators had in the 70s and 80s all agree that this is a moot issue. The ratification failed. And in order to have an ERA even introduced again, you have to start all over and use the right processes.
So an emphasis on process. Ashely, let's talk about feminism. You've written about this extensively and the broken promises of feminism. What's pushing this ERA now?
Well, you know, feminism is now what I call nothing but a political lie. And I think that's because at a certain point, the women's rights movement got too entangled with abortion. And abortion is a deeply divisive issue. Women themselves are split down the middle on the issue. And ultimately, as Mary said, quoting Alice Paul, it's deeply exploitative to women. But the problem is that if you are somebody who is in favor of promoting the rights of women, you oppose the discrimination of women, if you're not a card-carrying member or supporter of the abortion movement, you're out of the game. You're not only are you not relevant, you're a threat. And that's why I think feminism, the promises of feminism are broken or they're certainly on hold. And the problem with the Equal Rights Movement or the Equal Rights Amendment is that now this latest push, it's just a Trojan horse for abortion. And I think that's because the abortion rights movement sees what's coming potentially down the pike with Dobbs, which would be the overturning of Roe v. Wade, which would just restore the question of legislating abortion to the states and give the people a voice in the issue, and they just can't abide by that. And what adopting the Equal Rights Amendment would do would codify Roe v. Wade, and that's why they're pushing this right now.
And however, Ashely, you have written about a true feminist movement, a true push for equality and for a full understanding of the human person and the female. Tell us a little bit more about that.
Well, certainly. I mean, for one, it starts with celebrating women as women and what makes us different. And that requires, I think, celebrating and protecting and respecting the fact that we are the ones with the unique capacity to bear and give life. And I mean, what people are seeing is so insane. This talking about pregnant people, basically erasing the role of women in that unique gift that we have. And it's just another way that feminism has basically turned into a threat to women. I mean, it's used to actually discriminate against women who are, in the doula practice, who are being forced to adopt language that, not only is not scientific, but basically sort of whitewashes out the actual unique biological nature of women. And so I think we have to sort of step back and establish a new women's rights movement that, for one, disentangles itself from abortion, and two, sort of entrenches our celebration, embraces what makes us women, what makes us different. And that's where you're going to see, in my opinion, real progress when it comes to some of these, in my view, genuine claims about discrimination against women who are pregnant, and the different struggles that women face. But that has to start with understanding that women are different and not being afraid of that.
Mary, you talk about the politics of this often. There's a technical issue here around the U.S. Archivist, the person that takes the opinion from the Department of Justice and decides whether this is null and void or not. And he's or she will be a new pick by the Biden administration. Tell us about that.
Well, in making this a public issue again, what the Biden administration is doing, even through its archivist, through its Office of Legal Counsel, is it's sort of gaslighting the American public, and I think especially American women. They know that's coming at the midterms is going to be what some political commentators are calling a red tidal wave. There's going to be tremendous backlash against Democratic incumbents, and you look at the popularity ratings of this president and his administration. So it's to put this sort of power into the hands of the archivist. First of all, it's gaslighting, because the archivist doesn't have the power of Congress, and the archivist's opinion really doesn't have very much to say in opposition to a Supreme Court decision that has already indicated that ratification of the Equal Rights Amendment failed. But I think the Democrats, whether it's in statewide offices for governor, like in my state in Illinois, or nationwide, they think that when Dobbs is handed down, that this is going to be an issue with the American people that will drive more people to the Democratic Party. But the exact opposite is true, because what we know from any reputable poll, when you ask American voters, even American women, as Ashely mentioned, American women are deeply divided on abortion, about half and half. They say that they really want to see abortion legal for the first trimester only. And even within that distinction, they make additional distinctions for serious reasons, as they would call them rape or incest, exceptions like that. But they do not want to see a country where abortion is legal for all 9 months for virtually any reason. I mean, the United States stands with, I think, 7 other countries that have this kind of extreme permissive abortion law. What the Biden administration is doing is simply trying to kind of play a little shell game here. And the ERA is the P, and they're just moving it around. They're shuffling it around between their archivist and their Office of Legal Counsel. And then, Jen Psaki saying something about it. But they don't have the authority of Congress. And that's all there is to it. This amendment failed. They need to start over again. It never really captured the hearts of American people, even American women. And, a lot of lawyers would say, this is redundant. After the Civil Rights Act and the Equal Pay Act in 1963, we don't need an Equal Rights Amendment.
So we're turning something that should be about discrimination into something political. Let's talk a little bit about, just because we're running out of time, Ashely, the church and the way that the church talks to us about women. You came into the church, you're a convert because of Humanae Vitae. Tell us what that says and why it matters.
Sure. Well, I think it's sort of the theological version of what I was saying. The church uniquely celebrates women as women, our gifts as women. And I think it's a beautiful thing. I think that the church, and I think is increasingly realizing that actually speaking really boldly about sex differences as a beautiful thing, that the foundation of sexual equality begins in celebrating what makes men and women different with complementarity, that we bring different things to the table, and that right there is not a threat, but is actually the beginning, the seeds of true equality between men and women. And I think that's a beautiful thing, and I hope that the church continues to speak that truth boldly, because it brings people like me into the church, coming from I was in a very secular environment, and that was such a beautiful and stark contrast to what you see in the culture, that it really draws people in.
Well, I'm grateful to you both for this conversation, and we'll be watching this issue very carefully. Thank you.
Thank you.
Thank you for having me.